Welcome to the Pierce & Shaw's Personal Injury Postscript.
Hello and welcome back to Pierce & Shaw's Personal Injury Postscript with Chris Schaus. Chris is a Baton Rouge personal injury attorney who has been representing clients across southeastern Louisiana for more than 30 years. He began his career in insurance defense before founding Pierce & Schaus in 1992, where he now focuses on helping accident victims rebuild their lives with clarity, compassion, and strong trial advocacy. I'm Lisa Mosbey, your host, and today we're talking about pain and suffering in Louisiana injury cases. Welcome back, Chris. Thanks for joining me again.
Hi, Lisa. Good afternoon. It's good to talk with you again.
Thank you. Chris, to start, could you explain what pain and suffering legally means in Louisiana?
It varies some, I think, from people's common sense expectation. Maybe it's just more thorough or more broad. Everybody says, well, pain and suffering is when you're hurt and then when you're miserable because you've been injured. And that's certainly true. There are a number of components to it, though, and the court sometimes in examining it breaks it down into physical or mental or emotional pain and suffering. They have some differences, and so they get treated a little bit differently. They get proven differently. And certainly, for physical injuries, there are some fairly predictable indicators. Anatomical impairment ratings. I suffered an injury to my ankle. It was a 10% impairment of the ankle. It was this percentage of the left leg, and that converted to X% whole body impairment. And so I now have a 4% whole body impairment rating under the anatomical impairment ratings. And then there is mental and emotional pain and suffering. And we all, know tragic cases of folks who are unable to function because of grief and pain and distress and things like that. There's a temporal element as well, past pain and suffering, future pain and suffering. I suppose in terms of pain and suffering, people ask about derivative, consortium losses. The husband was injured and the wife was awarded damages. So she lost his ability to provide for the household, his ability to take care of the home, maintain the house, maintain the yard, maintain the vehicles, that kind of thing. Lost his ability to provide in the future going forward for the family. All of those are different elements. Consortium people giggle about it because, that's about an impact to the marriage, to the marital relations of husband and wife. There are 7 elements in consortium. That's just one of them. It's much broader than that. And it's the kind of thing that comes from spending a lot of time and energy trying to understand and quantify those damages. You ask, I believe, if there were set numbers. And I'd say, no, there's not. It is axiomatic in the law that each case rises and falls on its own merits, and no 2 injuries are identical. And even the same injury to 2 people might have different impacts. And so, yes, guidelines are used. Well, a judge might tell you, well, for a mild soft tissue, I start at X per month of treatment. But it depends on how that injury develops and how the treatment goes. Was it more intensive at the beginning and tapering off? Those are all factors that go into it.
And Chris, when you meet with new clients, how do you help them understand what their case might really be worth?
It's a difficult thing to answer until you've got data, because it's not just I had this injury, it's X dollars. Maybe at the 10,000 foot level that works. But most injuries are particular and personal to that person. A person who injures their left hand but is right hand dominant maybe is not as affected. But they already had a disability to their right hand, and so it turns out they're not typical to a non-dominant hand injury. Injuries have remarkable variety and quirks to them, just as their host people, claimants, do. And so it's very much a personal thing, and it's a big part of what we do. how can I effectively communicate to judge or jury how this poor lady's life and family were affected by these injuries? It's something that takes some creativity and some thought.
And I'm guessing maybe the evidence isn't always obvious. So, what kinds of evidence help to prove pain and suffering since you can't exactly quantify it?
Well, typically it's building blocks, and the first block is typically medical records. Here's what you presented with. Here's what they found when they went to do the surgery or therapy or whatever the regimen is. Here's what they found. Here's how it typically affects people. Then we go off and look. Did you have to hire new help around the house, a cleaning lady, a yard man? Did you cancel that project? Did you cancel that vacation? Were you not able to take that promotion? Could you not go work that special overtime project? How did those injuries disseminate out into your life and affect it? And that's, it can be tedious. It's another place where it's key to have good communication with your client. Folks, often, I don't want to sound like a whiner. I don't want to sit here and list all the ways this accident was a pain in my butt. But really, we need to know. We need to know. Some of it we may discard, but a lot of times it is those comments and those little personal tidbits. A juror says, "Ooh, he had that. I had that too," and it's those kind of things that jurors hook on and make their decisions from. So we want a lot of communication in that phase, because more communication, we investigate more accurately, and we present a better case.
A lot of sense to me. Do insurance companies treat these damages differently than medical bills or lost wages when they're deciding what to offer?
Yes, they do, and it's gotten more complicated in the last handful of years as we walk the path of tort reform. In Louisiana, collateral source has been the law for many years. We were one of the few jurisdictions that still recognized collateral source, and we have mostly moved away from it. So what that means, it used to be in Louisiana, you got hurt, you went to the doctor, you got a bill, the judge or jury got that doctor's bill, and that was a special damage. Lisa had a medical special of $500 from that doctor's visit. Now, it's not what the doctor billed, it's what the insurance company paid. And so the at-fault driver doesn't owe the bill. He owes what the insurance company paid. It gets more complicated than that, probably more so than we can go into in this format. But those are special damages, and that's pretty much a mathematical computation. General damages, pain and suffering, loss of enjoyment of life, future losses, consortium loss, all of those hedonistic damages, damages that can't be precisely quantified, but are significant nonetheless. Yes, they get treated differently. And while the medical bills, hey, they saw them, the doctor attributed it to the accident, we need to pay that pain and suffering. Maybe she was already unhappy in her marriage before this, and that didn't come from this. Or maybe there's some other condition, pre-existing condition. Those are much more dependent on testimony and the kind of supporting circumstantial evidence. The family member saying, yeah, she doesn't do that anymore. It used to be something we all enjoyed, but she can't do it anymore. We can't go on that annual beach trip anymore. She can't get out there. Those sorts of things. They're much more challenging to prove. And so we need to hear about them and get some insight into how the family is affected to be successful in proving those sorts of general damages.
Chris, let's talk about testimony. You mentioned testimony. How does someone's credibility affect how much weight their pain and suffering claim carries?
The witness's credibility, the plaintiff's credibility, is always a very important factor. you know, it changes from case to case. A plaintiff who was rendered unconscious early in the accident is going to have much less testimony about what happened than somebody who wrote it all out and watched it all. Some folks really come across as very credible witnesses, and, you know, that makes it to the defense analysis report. When that lawyer or adjuster who took a statement or deposition is reporting, that's one of the things they report on. This witness seemed very credible, and I think a jury is going to accept what her testimony was. Or conversely, this fellow was drunk when he showed up and didn't remember much and changed his testimony all throughout. The testimony is very important. We try to let our clients know what to expect in their deposition, what questions are going to be asked, how to address them, why those questions are going to be asked. It's important, and preparation of a witness for a deposition is something that I think only comes from years of practice and from taking those witnesses to trial and seeing what happens. So yeah, it's credibility is a big part of it, and where your lawyer is trying to work with you to bolster that.
I'm coming back to the money piece of it because it's something that everybody wants to talk about. Chris, can you tell us, are there limits on pain and suffering damages in Louisiana, or can awards vary widely from case to case?
Yeah, that's yes, they can vary widely from case to case, and often because of factors inherent to the cases. We don't generally have limits. Medical malpractice definitely has limits and has in Louisiana since 1973. Our legislature in the session that they proposed and discussed a limit on general damages in pain and suffering claims of $500,000. That limit did not get enacted, but the tort reformers are coming for it again. And of course, you know, there's a tremendous mass of accidents where that limit is not a factor. The problem is this: why would severely treated people not be able to collect 100% of their damage, but people with lesser injuries be able to? It's a problem we run into all the time with, well, there's only so much insurance or resources available. But what statutory limits do is, even if there's $1 million of coverage, we're saying you can't get it because we think our law says there is no injury worth more than $500,000. There's no logical basis for that. And thus far, the legislature has rejected it. But insurance companies have tremendous influence in legislatures, and we're seeing it in Louisiana. They're making big headway, and we'll be fighting for some years to undo some of the damage that's been done here. And it's always funny when you get folks in that, oh no, I'm totally in favor of all that. Here's how it affects your case. Oh, that doesn't seem fair.
And you've seen hundreds and hundreds of these cases. You know, in your experience, what kinds of life-changing experiences tend to move the jury the most when they hear what the client's been through?
You know, injuries to children and young people are always very powerful, and injuries to families. I'm involved in a case now that where 2 or 3 family members are deceased as a result of a terrible accident. Those things, you know, ripple out and down through generations. So yeah, we certainly deal with on occasion with real tragedy. Everybody that comes in wants to know, what's my case worth? What your case is worth is based on the evidence. Until I have all of the evidence, I've kind of got to hedge my bets. Nevertheless, you know, if you are a woman with a lumbar injury or a cervical injury, you're going to be in this range. If you're a worker, a male that does physical work and has that same injury, the numbers move a little bit. Certain injuries, broken rib. A broken rib doesn't get much treatment, causes a lot of pain. They tend to kind of come in around the same number all the time, although it depends on how much other trauma is associated with them. So yes, when folks come in right after the accident, we can give them a range of what that sort of injury is worth. As the medicals come in, that range gets narrower and narrower, and we can say, okay, here, at this point, you're finished with treatment. We know all the effects, and yeah, we can put a value on it. I don't want to hide those numbers from my client. I always want them to have a realistic idea of what their claim is worth, but I don't want to just make up numbers before the data comes in, because it's all driven by the data. That's the question people come in with. Well, what's this claim worth? And we can give them enough idea that for them to make the decisions they need, even right at the front.
Sure. And then, for someone who's recovering from an accident right now, what's the best way to document their day-to-day pain so that it doesn't get lost later on through the process or through the trial?
Folks do that differently, and a lot of people just fail to do it. As a lawyer, I live and die by the calendar. I am looking at a calendar every day. And for folks, everybody who's got a phone has a calendar. And I try to encourage them to just make a few notes. It doesn't need to be a journal. It's not journaling. But if you can make, Tuesday, I took some aspirin. I had some headaches. Wednesday, I had to miss work because my pain was so bad. Just a little bit of notes in a calendar like that can be very valuable. It'll help you remember. The Tuesday note, that plaintiff says, oh yeah, that was the day after Memorial Day weekend, and I had tried to mow between rainstorms, and turned out that was too much. And so that note on Tuesday that says I took aspirin, my back was bothering me, leads them to, oh yeah, that was the first time I tried to mow after the accident, and I'm not able to mow. That's when I called and got a yard man. So just a few notes like that can really be helpful, because you may be speaking of this months or even years later, and some note is helpful. So I encourage people to do that.
Thank you so much for your insights and guidance through this process. We appreciate it.
Yes, ma'am. Yes, ma'am. You're welcome.
Folks, thank you for listening to Pierce and Schaus Personal Injury Postscript. If you've been injured in a car, truck, or motorcycle accident in Louisiana, don't face insurance companies alone. Visit pierceandschaus.com to connect with Chris and his team. Be sure to like, subscribe, and leave a review if you found this episode helpful. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.